Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I would like to talk about the U visa, and if you happen to have committed the crime in California, how the new law, the new penal code law in California is going to help tremendously with the ability to actually get the U visa. So let me just give you a brief background so you understand why this law came into effect and what the background was. So if you were a victim of certain crimes, and I'll get into that later, but if you were a victim of certain crimes and you were, of course, not a lawful permanent resident or U.S. citizen, even if you're here illegally or your visa expired or whatever it is, you had the opportunity to apply for the U visa. And then, as part of the U visa, the law said that you had to get a certification from a government official. Usually it's the police, the detective, sometimes a judge, and without the certification, you could not get the U visa. Okay, it didn't matter how severe the crime was. It didn't matter any extenuating circumstances. If you didn't get the certification, you couldn't get the U visa. So, all over California, these police stations started making up their own rules. For example, a few of them would say, well, if the crime's older than 2 years, sorry, we're not going to certify. Nowhere in the law did it say that. Nowhere was there any regulation whatsoever that after 2 years the U visa is no longer valid. It was just ridiculous. Someone could have been raped by 13 people, had the strongest U case on the planet, and if it occurred 2 years and 6 days prior to requesting the certification from the police department, they would just say, so, sorry, we can't do it. Okay? And so these silly and ridiculous policies that had nowhere in law, had no backup of regulations, and frankly they just didn't have the authority to make these kind of limitations, and the fact they turned great U cases into garbage, all led to essentially an outcry that it's not fair what they're doing. They're either being lazy, or they don't want to have to take the extra mile to sign the documents or to certify, whatever it is. It was basically, in my opinion, a manner of just limiting the work that they had to do. And while I do respect that they have a lot of work to do, the person who had the crime committed against them had a right to get a U visa. It's not their fault that they, are submitting the paperwork more than 2 years after the crime may have occurred. A lot of times people don't even know about the U visas until, for example, they come into my office, and sure enough, they will see, I'll see that there's a U visa possibility. So anyways, given that, the great thing about the way law works is, the outcry came. There was a lot of years, actually, of fighting against this. And then finally, the legislature of California decided to actually make a law which delineated the opportunities and the procedures for doing what needs to be done for a U visa, which takes out of the equation these local police departments to basically turn the other way and say, sorry, we're not going to do it because of whatever reason we just made up. So I'd like to go through a little bit with you about the new law. It just came into effect as of January 1st, 2016, so it is valid law as we speak. And for all intents and purposes, it may be able to be used to get old U cases up and running again, depending on the retroactivity of this particular law and the arguments that the lawyers would make that it should be retroactive to allow people who were wrongfully denied certification to get the certification in order to apply for the U visa. So anyways, I'm doing this video in a little different place than usual, so if you get bored, you can look behind me and people watch, okay? So the new section which has come about is Penal Code, and there's a few different sections, but basically it's under Section 679 and 680. And what it starts off, first of all, is essentially a statement by the California legislator that says that it is their intention to give these victims of crime essentially the benefit of the doubt, and it's their intention to help the victims of the crime. So just in the first paragraph itself, it's making clear that the entities who were stalling the certification and not allowing the U visas to properly go forward do not take precedence over the victims of the crime itself, that the victims of the crime are the ones that need to be looked at and need to be given preference and priority regarding the U visas. So what else does it say? The first section starts off with definitions, of what the crime would be, and the U visa itself has a definition of the actual crime, but it makes clear that it could be a misdemeanor or felony. It also specifies what the victim is. The victim, of course, is the person whom the crime was committed against, and it also specifies what the witness or who the witness will be. Basically, it's someone who can be called to help in a particular case, even though they haven't been called yet. So, part of the U visa arguments are that this person was helpful or would be helpful. And a lot of times, people come to my office and they haven't even made the police report yet, and it's been a long time. So, especially with this new law out, we can certainly put in front of the police a report and let them know that in accordance with the sections of this particular section, that even if proceedings have not commenced, that they could be a valuable witness in the future. Okay, so that's the initial section. So the next section, which has quite a few provisions, I'm not going to go over each provision. I just want to somewhat summarize more or less what they are. Essentially, it is a it shows or gives the statutory rights of victims and witnesses of the crimes in the state of California. Okay, so it's really like a Bill of Rights for victims. So they're to be essentially notified that a court proceeding may go forward, and that they may or may not be required to be a witness. They are to be informed by the prosecuting attorney of the final disposition of the case. And then for the victim's parents or guardian, if the victim's a minor, or the next of kin of the victim, all have to be notified of all sentencing proceedings and the right to appear, and to reasonably express his or her views, have those views preserved by audio or video means, and to have the court consider his or her statements. Okay, so they don't want the victim to just be sitting in the back without letting the court know, and it's not required, but if they want to, letting the court know about how they have suffered essentially from being a victim of the crime. The next one is for the victim or the victim's parents or guardian. Again, if the victim's a minor or the next of kin if the victim has died, to be notified of all juvenile disposition hearings in which the act would have been a felony if committed by an adult. Okay, and the right to attend and to express his or her views. Again, letting them know what they think type provision. Then the next section is upon request by the victim, and again, it includes the other people as well if the victim has died or, next of kin, so forth, to appear personally or by any means as provided in the code to express his or her views and to have her statements considered. Okay, so the first few sections here are very hit very hard on them being able to express their views on what happened and how it affected them. And in the next section, if there was a homicide, is basically it's upon the request of the victim or the next of kin, if the crime was a homicide, to be notified of the inmate's placement in a reentry or work program or notified of the inmate's escape. So lots of notifications here. So, whereas before nobody, could find out anything about many different things, it's statutorily being put in here now. It's also to be notified about whether they're going to be entitled to witness fees, for a victim to be provided information concerning the rights to civil recovery and compensation, to the expeditious return of property which has been stolen or embezzled from them, and this is rights that you give to the victim, part of here to an expeditious disposition of the criminal actions, and then to be notified if the defendant is to be placed on parole. And then for the victim upon request, some of these are upon request, so they don't have to do it unless the victim asks them, but to be notified of any pretrial disposition of the case. And then again, all of this helps with the U visa, because if the victim is not the one being prosecuted, generally they're not given all this notification of what it is that's going on. And if they can get that information through this request, then we have all these other people that might be able to help certify for the U visa. So if we go on, for the victim to be notified by the district attorney's office of the right to request various notices for various offenses, and it goes on to different offenses for assault and various sexual crimes and so forth. And then when the person has, or the victim has requested that particular notice, then the sheriff has to inform the victim that the person who was convicted of the offense has been ordered to be placed on probation, and give the victim notice of proposed date upon which the person will be released. Okay, so all this to protect the victims. So it goes on with some more items, but that's basically the Bill of Rights for the victims. And then the next section goes on, and it essentially states that every victim of the crime has a right to receive without cost a list of rights of the victims, which is what we just went over, and it goes on to list several different sections, even that they are supposed to get a PDF file and what's called a Marcy Rights Card, which contains all of the rights. So all of these people who are victims of crime are not essentially just left out in the cold. So lots of provisions in the beginning about notification to the victim, what the victim can request, further items that the victim is able to have. Now, the next section is basically dealing just with persons who are victims of a violent offense. Okay, and then I'm sure there's going to be lots of litigation in the future about what is designated as a violent offense. But again, there's certain provisions regarding notification and witnesses and next of kin and so forth, and the creation of the electronic notification process and so forth. So lots of work for them to get forward. Now, the next section deals a lot with victims of sexual assault, okay, and what it is that they are allowed to do and to request, and that they're allowed to be notified orally or in writing. It depends, however it is that they want, and their rights as well. So lots of different rights here, and if you email me, I'll be able to send you more specifics. And then the next whole section deals with victims of domestic violence or abuse, and essentially what their rights are, and who's allowed to be present during interviews and so forth. There's lots of different sections as to protecting these victims of domestic violence, and who can actually do the interview and so forth. Now, as specified above, the victim's rights card is essentially going to be a type of card that has all of these rights on this particular card, and what it is that they are allowed to do and who they can do it for and so forth. Now, we get all the way down to this section, and hopefully you're still listening. And the next section deals essentially with certifying entities, and this is the crux of what was stopping the U visas from going forward before. I mean, still the U visa has to be prepared, and still it has to have all the supporting documentation, but now the this section codifies all kinds of information about the certifying entity. So first it states that the certifying entity essentially is a state or local law enforcement agency, a prosecutor, a judge, or any other authority that has responsibility for the detention or investigation or prosecution of a qualifying crime or criminal activity. So that's pretty broad. That section there is really pretty broad, because normally you would not have been able to go to someone who is in charge of detaining a person in order to get that certification. It goes on that agencies that have, and this is still continuing with who has what a certifying entity can be. Also, agencies that have criminal detection or investigative jurisdiction in their respective areas of expertise, including, but not limited to, Child Protective Services, the Department of Fair Employment and Housing, and the Department of Industrial Relations. You see what they're doing. They're trying to widen the door for entities that can certify U visas. They're trying to make it easier and more efficient. Now, it goes on to specify those were the entities. Now, a certifying official, what is the actual person at the entity that can sign the document? Well, it's the head of a certifying entity, or a person in a supervisory role who has been specifically designated by the head of the certifying entity to issue the Form I-918, that's for the U visa. A judge, it could be any other certifying official defined, and then it gives various statute under the Code of Federal Regulations. So right there, I mean, I think this is a great part of this new law, so that widens it quite a bit. And then it goes on to list what qualifying criminal activity can be, and essentially this lists all the various crimes that are in the U visa. I will go through it real quick here: rape, torture, human trafficking, incest, domestic violence, sexual assault, abusive sexual assault, prostitution, sexual exploitation, female genital mutilation, being held hostage, peonage, perjury, involuntary servitude, slavery, kidnapping, abduction, unlawful criminal restraint, false imprisonment, blackmail, extortion, manslaughter, murder, felonious assault, witness tampering, obstruction of justice, fraud in foreign labor contracting, and stalking. So those are the main crimes. It specifies that a qualifying crime includes criminal offenses for which the nature and elements of the offenses are substantially similar to what I had just gone over. So that's not a full all list. If you've been a victim of some other crime, and we can show more or less it's similar to one of the ones listed, then there's a chance at the U visa as well. So don't give up just because what you were a victim of is not exactly listed on that particular list. And then it goes on to say that upon request of the victim or victim's family member, a certifying official from a certifying entity shall, and I love that word, shall means they have to, okay, shall certify victim helpfulness on the Form I-919 Supplement B certification when the victim was a victim of a qualifying criminal activity and has been helpful, is being helpful, or is likely to be helpful to the detection or investigation or prosecution of that qualifying criminal activity. So do you see that there's still a little playroom for them to say, well, they never helped, or they didn't really, but at least now it has completely closed off that loophole where the certifying agency would have had to have been able to say, oh, sorry, we don't feel like doing it, or it's been 2 years and 3 minutes, can't do it, that's our policy. So it's taken that out and codified it, which is really good. Now, in order to further help the victim, it says here, for purposes of determining helpfulness, which is what we just discussed, they have to, the victim has to have been helpful or will be helpful. There is a rebuttable presumption that the victim is helpful, has been helpful, or is likely to be helpful to the detection of or investigation or prosecution of that qualifying criminal activity if the victim has not refused or failed to provide information and assistance reasonably requested by law enforcement. So this is fantastic. It has completely altered the burden. The victim does not have to now prove that they will be helpful. The certifying agency must prove that they were not helpful. Okay, it changes the burden, so when they walk in the door, they're already assumed to be helpful, and only if the police department or certifying agency can point to facts they weren't, will they not have to certify. Okay, then going on, the certifying official shall, again I love that word here because it mandates they do it, fully complete and sign the Form I-918 Supplement B certification, and regarding victim helpfulness include specific details about the nature of the crime investigated or prosecuted, and a detailed description of the victim's helpfulness or likely helpfulness to the detection or investigation or prosecution of the criminal activity. It goes on that a certifying entity shall process an I-918 Supplement B certification with 90 days of request, unless the non-citizen is in removal proceedings, in which case the certification shall be processed within 14 days. So if you happen to be in deportation and qualify for a U visa, you get that certification request out and you're going to get it back in 2 weeks. And if you're not in removal proceedings, you're going to get it back within 90 days. So, this is another issue that sometimes they would sit on it for months and 6 months and a year, and they get to it when they get to it. So now they have specific time deadlines in which to move forward. It goes on to say that a current investigation, the filing of charges, and a prosecution or conviction are not required for the victim to request and obtain the Form I-918 Supplement B certification from a certifying official, which is great, because a lot of times they would deny it because they say, sorry, there was no case, we didn't file charges. Okay. Goes on, a certifying official may only withdraw the certification if the victim refuses to provide information and assistance when reasonably requested. That is the only way, and you're very rarely going to get some victim that you're going to have some evidence that that person just said, nope, I'm not going to help. I don't care who did this to me. I'm not helping. Okay, and then it goes on. A certifying entity is prohibited from disclosing the immigration status of a victim or person requesting the U visa certification except to comply with federal law or legal process, or if authorized by the victim or person requesting this certification. So it's great. You don't have to be afraid by doing this and coming forward that the police will report you to immigration. Okay. Goes on. A certifying entity that receives a request for this form shall report to the legislator on or before January 1st, 2017, and annually thereafter the number of victims that requested it and so forth. So obviously that's the way of them keeping track of it. So there are other, other parts of this law which we don't really need to get into it now. This was the crux of what I wanted to discuss and why it is such a great place in which to have this particular law. So basically, if you have questions, give me a call. The U visa applications now are wide open and ready to go forward. So if you like the video, click like, subscribe, and more videos in the coming weeks.